Hey guys, how are we? Well, it's been a hot minute since I last did a Discord and since I last did a live actually. For those of you that maybe haven't seen this before, because I've had a lot of new followers this year, thank you so much. I'm actually live on Discord. So if you want to ask me a question, by all means, come into the Legal Queen Lounge. And you can ask me a question there. The lounge is already filling up, so there's a lot of people clearly who have got questions for me, which is absolutely fine. I'm also live on TikTok and Instagram. So guys, for those of you that are in the Discord lounge and you want to ask a question, please know that it's not just us that that are going to hear you, but everyone on TikTok and Instagram as well. So let's kick off without further ado. Lisa, you have your hand up. I've just sent you an invitation to join me on the stage. How can I help?
Hello.
Hello.
Hello. So just a quick one. So it's child maintenance related.
Right.
My daughter turned 16 in October.
Yeah.
There's a child arrangements order in place. I believe there's two parts to it. So there's the lives with order, which is with me.
Yeah.
Which I believe is just for like holidays and things like that. So that I don't know whether I was a mission. And then there's contact reasons only.
Yeah.
My solicitor, I'm under the understanding that from the solicitor that for the contact reasons only, the child arrangements side of it, that the child arrangements order will end at 16. How do I, because I contacted child maintenance because my daughter hasn't stayed with her dad or had any contact with dad now since December 2023.
Yeah.
And when I brought that to child maintenance attention in April 2024,
Yeah.
they contacted dad and said, is this right? And dad turned around and said, no, there's a court order in place. I'm still having her every other weekend and half of school holidays, which is incorrect. He just obviously doesn't want to pay the correct amount. And obviously because it's a lawful arrangement, child maintenance have to go by that.
Yeah, they will be guided by that, Lisa. Yeah. So what's your question of me?
So when she turned 16,
Yeah.
how do I prove to child maintenance that the child arrangements order has now ended for them to recalculate the correct amount that he should be paying based on no overnight care?
So you're not going to be able to prove it, like legally prove it by way of a document, because obviously you have the court order. All you can suggest to child maintenance is that, you know, she no longer wants to go and see her father. You can't go back to family court because she's 16. We won't get a child arrangements order once they hit 16. And you would just hope that, you know, they believe you. But there's no sort of legal way to prove that. There's no evidence as such. And they may decide, maintenance, CMS may decide that actually they're going to adhere to the order. And regardless of the fact that she's not staying with dad, they might still be guided by the order. It's a difficult one. It's a difficult one.
Yeah, because obviously the order does, my solicitor said it ends at 16. He's under the belief it ends at 18. I don't know why. It does end at 16. I mean, I've been all through Google, government websites, solicitors' websites. It ends at 16. I just don't know what I can send them because obviously I don't know why court orders don't come with an end date. It would make things so much easier.
Yeah, you can ask for I mean, it's too late now, but for those others that are listening, you can ask the court to put an end date in. Absolutely. Unfortunately, you've got your order now, Lisa, and you're not able to go back and vary it because she has hit 16. You would just hope that CMS will take your word for it, really. But that's probably as far as I can take that one.
Yeah. I mean, she doesn't turn 16 until October, but the wait times in my family court area, I'm not going to be seen by the time she turns 16.
No, because by the time you make an application, you're not going to get a hearing date for at least 3 to 4 months anyway.
Yeah, so I'm guessing, would a letter from my solicitor help?
Potentially. Yeah, potentially. I mean, it's probably a better question for CMS, if I'm honest with you. We don't deal with CMS directly, and we don't have anything to do with the maintenance side of things. So a better question for them. But look, it's not going to hurt, is it, to get a letter from your solicitor, I mean.
Yeah, I mean, I'm happy to pay for that, but I think the problem with CMS is every time you ring, you speak to someone different, you get different advice from them.
That's so true. That's so true.
But yeah, all right. I'll send over what I've got if he wants to you know, disagree with what I've said, I think I'll just have to appeal it and take it further.
Take it further. All right, Lisa. Well, good luck
Yeah.
with that.
All right.
Thanks.
Thanks ever so much.
Bye.
Cheers. Bye-bye.
Hi there.
Hello.
Can you hear me okay?
I can, yeah. What's your question?
So I have a child arrangements order in place.
Yeah.
We went to court last September, again for a child arrangements order to be changed to go to a contact centre to minimise the abuse that I was getting from my son's father.
Yeah.
That didn't quite go and happen due to financial reasons, but we had signed an oath to say that there would be no more horribleness and nastiness from the other parent.
Yeah.
We had also changed my son's surname to a double-barreled surname, which had been approved by the judge. The way my son's father had conducted himself in that hearing was just really awful, quite frankly. And in our final order, it is actually noted his behaviour was described as extreme bullying and just no consideration for the mother. We had, like I say, we'd signed this oath to say there would be no nastiness, but since then there has been so many abusive messages. I don't respond, I don't retaliate. My question to you is, what is it that I'm actually applying for if I was to take it back to court? Because quite frankly, I just can't cope with the abuse any longer. What is it that I'm applying for when I go back to court to put a stop to this? And will the court actually do anything over abusive messages? And
so are you
also,
currently in the family court on a child arrangements application?
I'm currently not going to court at the moment. We have a child arrangements order.
You have one already. So I would
yeah,
suggest that you might want to take some advice about getting an injunction. So a non-molestation order, which prevents him. Yeah, go on.
Sorry, I had applied for a non-molestation order before.
Yeah.
This was before this last recent court hearing about his behaviour.
And what happened?
They basically just said, you need to take it back to family court. It's not really anything to do with us.
Okay, so when you say it's not anything to do with them, where did you make your application?
That was Norwich Court.
Right.
For a non-molestation order. I had provided evidence of abusive messages and just our history.
And did you do it yourself?
No, that was through a solicitor. So they had made the application for me, but they didn't represent me in court.
Okay.
They had obviously then said, this isn't really the forum fit for it. You need to go back to child arrangements to change the child arrangements order.
Okay. So I think there's a little bit of a confusion there then, Danny, because what you're saying to me is that you're being bullied, harassed, spoken to in a derogatory manner. And, it's obviously impacting you. And I totally get that. Yeah. That is a non-molestation order. That is an injunction. Okay. So I'm not sure. Okay. It could be a mixture of maybe, your evidence wasn't compelling. Maybe your statement wasn't firm enough. I don't know. It's difficult for me to say. For them to say that it shouldn't have been dealt with in this forum and go back to a child arrangements order leads me to think that, maybe the evidence wasn't great. I'm not casting aspersions on your previous solicitor, but it seems to me that we don't need, because the child arrangements order is only going to give us a framework of when the child sees which parent when. Do you know what I mean? That's all it's going to do. Yes, you can both give an undertaking that you're not going to speak derogatively, if I said I can't get my teeth in, towards each other. But essentially, if he is ignoring that, then you need a non-molestation, because that will prevent him from contacting you either directly or indirectly. And if he chooses to breach the non-mol, then obviously there's consequences. So then you're able to get the police involved, for example. And there will be consequences. He could be fined, imprisoned, community service, etc., etc. So if you think that you qualify, then obviously legal aid, they will help you get the non-molestation order. If you don't, my advice would be, and this is not just for you, Danny, but to anyone else that's listening, get some advice. Non-mols can be a little bit difficult. And And the essence of succeeding in your non-mole is going to be in your statement, okay? You've really got to have a professional draft that statement to drive home the fear that you're experiencing.
Yeah.
All right?
Okay, that's really
Lovely.
helpful. Thank you ever so much.
Pleasure. Thanks, Danny. Bye.
Bye.
What's the best way to progress in a situation where supervised contact has taken place in a contact centre due to DV against me in the baby's presence? Do I suggest handovers at a contact centre at his expense, as I'm not currently working? He's also on bail for DV.
Okay, then yeah, I would be suggesting that you do the handovers at the contact centre so that, you know, you are in a public place and there will be witnesses there. And I'm pretty sure that, you know, nothing's going to happen if you're in the presence of somebody else. Sometimes we'll get an order that says one of the parents arrive at this time, let's say 10 o'clock, and the other parent arrives at 10 past the hour, so that we are trying to eliminate the possibility of a crossover. Do you know what I mean? So we're not arriving outside together. Doesn't always work, but there are certain things we can put in the order to help. But yeah, do the handover at the contact centre, or alternatively, if you've got a family member or a friend that can do the handover for you, that's even better.
Okay, that's great. And one final one. What form do I need to use to force the sale of a jointly owned property?
Okay, if you're married, then you're going to be filling out a Form A. That's the form that's going to trigger a financial application. Prior to that, you are going to have to get the MIAMS form from the mediator. Now, the important thing about that is a lot of people think, oh, I can't do mediation. You know, there's been domestic violence, or mediation isn't compulsory. It's voluntary. So you have to get the form from the mediator, but that doesn't mean that you have to do mediation. But a Form A is going to trigger a financial application, and from there, you're going to be asking for an order for sale. Okay, so that's how she's going to start that. If you're unmarried, little bit more complicated, because we're not going through family court, we're going down the civil route, and I would suggest that you have an appointment with us if you're not married, because it's a little bit more technical.
Okay, that's all I've got for now, Tracy.
Oh, thank you, Captain. Good to talk to you.
Hi, Tracy.
Hello.
I've got a first financial hearing listed for end of May.
Yes.
The court directed that the exchange of Form E should have took place end of April.
Yes.
And they still have not shared Form E with myself.
Yeah.
They said they didn't receive them in the post, which I didn't either. And it was just that I'd asked the court when I was receiving notification of the conditional order.
Yeah.
So as of today, it's 2 weeks away. So I've sent my chronology, but obviously I can't send a statement of questions or anything because I haven't received anything from the other party.
Yeah.
I've informed the court of this. I've sent an email, but what can I do now? Because I'm aware that he has legal representation, so they can actually access my information on the court portal, which I've realised the other week.
Yeah. I mean, look, he's in a whole heap of trouble. If he's got a solicitor and he's not complying with the court order, then obviously you can let the court know of that when you get there for your first appointment. For those that are listening, by the time we get to the first appointment, we should have exchanged Form Es with one another, and we should have also have prepared a questionnaire so that we can ask the other side to provide answers to queries that we have about their Form E, okay? So by the sounds of it, you're not going to be there at that stage by the time you get to the first appointment. So what's going to happen is that the judge is going to have to adjourn it off, because the first appointment won't be effective if we don't have those documents. However, you know, we will adjourn if the other side is a litigant in person. However, if the other side have a solicitor, the court will take the view that the solicitor should know better. The solicitor should actually be working sort of night and day to get that Form E swapped with you, and also to get the questionnaires up and running. So all you can do at this stage is hound his solicitor, and then bring evidence of that with you to your first appointment. So you can say to the court, I've been completely disadvantaged. The other side have had sight of my Form E. I haven't had sight of theirs. This is my application, and we still haven't exchanged questionnaires.
Okay, that's great. Thank you very much for your help.
Pleasure. Okay, thank you. Bye.
All right. Thanks, Tracy. Bye-bye.
David, how can I help?
Hey, Tracy.
Hello.
I had an agreement with my ex with a D81 financial order, all agreed about 18 months ago.
Yeah.
The judge pushed that back and said they needed more information. And long story short, it's gone on for a long time, to and fro, but we finally got to an agreement. One thing she did now say, because I have the kids 100%, is she wants me to put in writing that I won't make any CMS applications against her. I actually don't have any intention to, but I'm uncomfortable with putting that in writing in case my circumstances change or you don't know what the future holds.
Yeah, you don't need
Yeah.
to do that, David. Honestly, you can't do that. If the children are with you full time, then you can't give a promise to the other side that you'll never need their help financially. And if I'm honest, morally, they should be helping you anyway. Regardless of who the children live with, both parents are still responsible for those kiddies. So I would suggest that you ignore that request and, you do you. You're looking after those kids. So, it's if you don't need to make the application, fine. To be honest, David, even if you did make a promise in writing, it wouldn't count for anything. Do you know what I mean? Because it's not a court order. So just a written agreement between you both, it's not legally binding, if she pushed and you sort of gave in. But I would suggest that you don't do that.
Yeah, because that's my fear is that I did put something in writing and, later down the line, she could legally take action against me if I did do that.
It wouldn't be legally binding. No, it wouldn't be legally binding at all. Only a court order is legally binding. And even then, once the court order is 12 months old, the child maintenance part of it drops away and jurisdiction passes back to the CMS anyway. So, she's. I wouldn't bother. I wouldn't bother.
Okay. Because what you're threatening is to not agree to the current terms in the D81 if I don't do that. But I don't see the point. It's not legally binding.
No, that's blackmail too. What terms are in the D81 that she won't agree to, unless you sign it?
I mean the actual terms she's happy with, but she's just basically saying if I don't do the CMS, she'll refuse to go ahead with to agree to the financial order.
Wow. I mean, look, you're caught between a rock and a hard place. You can put it in the D81. It's not going to be legally binding once that order's a year old anyway. It's not going to be legally binding full stop because it's not going into your order. It's going on the D81. The D81 is information for the judge, that's all. It's so the judge can have a bird's eye view of the party's financial position. That's the whole point of the D81. But yeah, I mean, look, if you want to move forward with your financial order, maybe put something in there. I don't know. It all just seems a bit sus to me because why is she blackmailing you like that?
She doesn't want to be. Well, she doesn't want to have the potential financial burden over her head in the future. I mean, she obviously doesn't believe me when I say I'm not going to enforce it anyway. But she's just trying to protect herself, I guess.
Yeah. Look, from your point of view, even if you put it in the D81, it is not legally binding, and at any time you can always make a claim to CMS if you need to.
Okay.
All right.
Okay.
So
Brilliant.
with
No,
that
that
information,
helps.
you make the decision. Yeah. Okay. Captain, I can see that you've got your mic off. How can I help?
Just a couple of things coming in on the last one.
Oh, yeah.
On the last caller on TikTok. People are asking, what is a D81?
Okay, so when we arrive at an agreement between two parties with regard to the financial order, we send the financial order into the judge. In order for the judge to be able to decide if that order is fair and reasonable, he has to have some more information. And that information is, what do the parties earn? What assets do the parties have? And what debts do the parties have? Do we have any children? Where are the parties living, etc., etc.? And the D81 tells the judge that information. And it splits it into two parts. So the first part of the D81 is, this is our financial position, judge, before the order is made. And the second part of the D81 is, and this will be our financial position after you've made the order. So it's just a check and balance really for the judge to make sure that the orders placed in front of him is a fair and reasonable one. And that, if he makes that order, no one's going to be left financially destitute. Okay, so it's just a little bit more information for the judge.
Hi, Tracy. I just wanted to ask, I've got a non-molestation order
Yes.
on a no findings basis against my hopefully soon to be ex-husband.
Yeah.
Initially, I went for it for the children as well, and I got it granted on an ex parte basis. But at the
Yes.
return hearing,
Yeah.
the judge said, normal is quite high. Criteria for it is quite high in respect of children. It's for the other party to make an application for a child arrangements order. He hasn't done that, but what we're doing at the moment is we've offered supervised contact as well as video contact, but the letters back and forth are costing me a fortune. At what stage do I say, look, stop? It's been on the table since the end of March and he's not taken up the video calls. He's just blindly denying his alcoholism, even though there's evidence to the contrary. But every time I'm sending a letter via my solicitor, it's costing me a fortune.
Absolutely.
Do I just invite him to make that order and then we'll get it looked at in front of the
Absolutely.
judge?
Absolutely. I mean, I get questions like this all the time, Kat, and it's a great question, not just for yourself, but for others who might be watching. A lot of times where parents can't agree and the parent with the children is offering contact in whatever form, it might be indirect, as you've suggested, or it might be direct, Saturday morning at the park or what have you, and the other parent is saying no to that, well, then negotiations kind of come to a halt then, don't they? So absolutely, I would stop because it is costing you and invite him to make his court application. Because when the court then get the matter before them, one of the first things that I'm sure you're going to be asking for is for hair strand alcohol testing, because your
We've already
concerns.
asked for that.
Sorry?
And we've already asked for that twice.
Yeah.
He's denying that there's an issue, and his solicitor keeps saying that my accusations are malicious.
So hang on. So when you say you've asked for it, do you mean in the court forum or just via solicitors' correspondence?
Via letters. We've said that we're happy to provide access on this basis, and we'll progress towards unsupervised once he provides hair strand testing.
Absolutely.
And engagement in a program.
So
they've come back and said, let's do that hair strand testing then, and they just keep going quiet on that front.
Yeah. So you've made your position really clear, and therein lies the divide between you both. He isn't acknowledging his alcohol issue. You are saying you have an issue. And that's when matters proceed to court, because the judge will order alcohol hair strand testing because it won't take the risk that you're not telling the truth. So absolutely, there is no point negotiating any further with indirect or direct or video calls or whatever it might be if actually we're not going to get to the root of the issue. So rip off the Band-Aid. My advice would be to, obviously have a chat with your solicitor because they know your case far better than I do. But I would be suggesting to the side that negotiations have gone as far as they possibly can. It's unreasonable sometimes to keep going from a financial perspective and invite them to make an application.
So in the interim then, if he doesn't take up that video or thing, and he hasn't spoken to them for 3 months now, so I just leave it?
Yeah, absolutely. You can't force him to do it. You've made the offer. You're doing what the court would consider to be in the child's best interest. What the law says is that it's the child's right to have a relationship with both parents. You are encouraging that. You are promoting that there's at least a video call once a week, twice a week, or whatever you've suggested. If he then decides not to do that, if the matter goes to court as your legal rep, I would be letting the court know that. We offered video, but for whatever reason, Dad didn't even want to do that. Most parents will take whatever is offered to them because they're just desperate to have some relationship with their children,
Perfect. Thank you.
All right. Pleasure. Thanks, Kat. Hello, Martz. How are you? How are you?
Welcome back.
I know. It's been ages, hasn't it?
It was a surprise when I seen you live then. I was like, oh, hello.
I know. We need to have a catch up. I need to have a chat, an off-air chat with you guys and let you know what's been happening. But so much has gone on. How are you? You well?
Yeah, I'm all good. I knew you were live anyway because my inbox was just going boom.
Yeah, sorry about that.
So I'll get on with these.
Okay, lovely. Thanks, Mark.
The first one I've got for you.
Yeah.
If I have a child arrangements order,
yeah,
is the other parent allowed to dictate my parenting time with supported contact can the third party be a hindrance, especially when there's bias?
No, so that the other party cannot dictate what you do when the children are with you, and they can't dictate who the children see and who you are leaving the children with and who you date and all the rest of it and what time you put the children to bed, etc., etc. If you've got parental responsibility and you've got a child arrangements order, when the children are with you, they are your responsibility, and the other parent needs to butt out.
Well, the next one is I'm trying to allow my daughter to have better relationship with her dad, but it's like he doesn't want the relationship. He's saying he's taking me to court for less time. He doesn't see her much. He only sees her on a Thursday for 3 hours. I've offered him phone during the week and offered every other Sunday to him, but I don't want that going to court. I don't know what to do, what's right. Just want to help my daughter. I'm just reading it as it is.
Yeah. I think what she's saying is that we can't. My answer to that is a standard. We can't force the other parent to have contact. I think what she's saying is that, you know, perhaps the daughter wants more contact, but he doesn't want more contact. You're at a stalemate there. It's sad, given so many fathers are desperate to have contact with their children, but that's as far as we can go, unfortunately.
My ex has got 2 university degrees and was in full-time work, has now got herself signed off work and is saying she has no earning capacity.
Yeah.
What can I do?
Well, I'd want to understand why she's signed off work. Is this a temporary measure? Is this just because we have some mental health issues? Are they short-term? Are they long-term? Do we have some bigger medical issues that maybe she can support with medical evidence that shows that she can't go to work? So I think that needs to be the focus there. If she's maintaining that she can't go to work, then let's have the evidence to suggest how long that's going to be, and why, more importantly. What you'd then want to do is make sure that whatever degree she's got, you can suggest to the court, well, these are the kind of jobs that she can apply for now, or at least go for, and these are the packages that are being offered for jobs, you know, for those types of roles. But it's really important to get the medical evidence clear.
And just to follow up, actually, the person just said to me that they refuse to provide any medical information to my solicitor.
Well, if the matter, now a solicitor can't force them to provide that information, but a court can. And of course, if they refuse to provide it to the court, well, then the court won't take it into account, because the court can't. The court has to have evidence, medical evidence, to suggest that you can't work before it's going to go ordering more than 50%, or before it goes ordering SPAS or maintenance. So they're going to come a cropper, you know, unless they can provide the medical evidence. That line of argument isn't going to stick.
I mean, do you see it a lot, Tracy, where people have been saying work for 30 years?
Yeah.
They're getting a divorce now, say they're on a 6-figure salary, but now
Yeah.
they can only earn 20 grand a year.
Absolutely. I would say in more than 50% of my cases, the other side is suddenly made redundant, or the other side's contract has come to an end. But that's okay, because it doesn't matter what's happening right now. If historically they have always been able to earn a certain amount, then that's what I'm suggesting to the judge. You know, okay, right now, he may not have a contract, or she may have been made redundant, but for the last 20 years, they've been happily earning 30 grand or 40 grand. So history will tell us they can continue to do that. And that's the position that we should be adopting when we're making the financial order.
Okay, that's all I've got for today, Tracy. Well,
Fab.
I've got more, but I know you've got other questions.
Yeah, okay. Thanks, Captain.
My wife and I, we're going through a divorce, but we're going through mediation at the moment.
Yes.
So after we spent so much money with legal fees with lawyers,
Yeah.
so she decided, okay, she'll go to mediation.
Yeah.
Now, the question is, she has a very big pension pot.
Yes.
That's bigger than mine. But I have a property. We both have a property, but we live in my own house that I bought at least 6 years before we got married.
Yes.
So we've been married for about 16, 17 years.
Yeah.
So she wants a large chunk of the property. So, but I want to use the pension to offset what I'm going to pay her. Now, how do I go about the pension sharing order? Applying for pension sharing order, or is it through lawyers, or can I do it myself?
So there's two ways. If you are both in agreement to offsetting the pension and you can arrive at an agreed lump sum, then you don't need to physically go to court and you don't need to make a court application, a financial application. You can simply have one solicitor draft the financial order for you and send that into court. And if you're both in agreement, you're both going to sign it off. However, if you can't agree and maybe she's looking for a bigger lump sum than you're willing to offer, or she's not willing to trade off the pension share or what have you, because people have different needs, then you're going to have to make the application. But you can still do that yourself. That's a Form A that you can download from the government website, fill that out, send it in, and that's triggered a financial application. 3 months then down the track, or 4 months, depending on what court you're applying to, you'll get a hearing date. And then you're both going to state your case to the court.
Okay. Now, to do the pension, someone said we'll need to go through pension actuarial to calculate what we're getting 50-50 sharing the pension.
So that depends. So that depends. That's a very bespoke question because it will depend on a case-by-case basis. The law says that all contributions made during the marriage, and in your case, you told me 16 years, they will be the contributions shared between the parties. If we are dealing with a pension that you've paid into for, let's say, 30 years, then yes, you may need an actuary's report to be able to ring fence those premarital contributions, okay? But not everyone needs the actuary. It will depend on if we have any non-matrimonial contributions, and if so, how many? So, for example, sometimes people have paid into the pension a year before they got married. I'm not going to advise that we get an actuary's report in that instance because they can cost a couple of £1,000, and we're dealing with 1 year's worth of contributions. It's not worth it. But if we've got maybe 5 years or 10 years of contributions, maybe we'll consider it, you know?
Okay.
All right.
All right. Thank you very much, Tracy.
Pleasure. All right then. Thank you. Bye. How is a fact-finding set out? Do you stand up and talk about events? Yeah, fact-find hearing happens within children's proceedings, and it is a hearing or a trial within a trial. So one person's made allegations about, usually it's, domestic violence allegations, and the court want to find some facts, find the truth there. So yes, it will be, both parties will give evidence and both parties will be cross-examined. And based on the evidence that's submitted and what the parties are saying, the judge will make a determination. The judge will make a finding as to which allegations they believe and which allegations they don't believe. And once we've finished with our fact finding, we can then step back into our children's application and we can continue, okay? What else is on here? Wife. I've never heard an answer. Can my ex-wife still make a financial claim after I get remarried? Yes, she can. As long as she hasn't remarried, then, and you don't have a financial order, yes, she can make a financial claim against you. You can't anymore because you've now remarried. So there we go.